Good morning, friends. Yesterday, the Honorable Supreme Court of India, two judges bench, K.M. Joseph and P.S. Narasimha, while disposing the case of New Okhla Industrial Development Authority, which is located in Noida, versus UNUS in civil appeal number 901 by 2022 on 3rd February, that is just yesterday. So you can see the citation in Live Law 2022 SC page number 123. So while disposing this case, the two judges bench clearly held that the award given by Lok Adalat, it is not a compromise decree, it is only a decree. Right? It is not a compromise decree. Lok Adalat. So now the provisions of Lok Adalat are necessary to be reviewed once again. So before that, let us have a cursory glance towards the facts of the case. Mr. Yunus and others, actually, they filed this case. So the appellant, that is Noida, New Okhla Industrial Development Authority, they have passed some planned industrial development. They have given a notification on 21/3/1983 for the development of the industrial estate. They called for some parties. The parties came there. They wanted to establish some industries. So they wanted some land. All these things were there. So please remember, the land acquisition officer fixed the land rate as rupees 290 or 200 per biga. So for yard or for ground, we don't know. People will call it. Here we call it as ads and cents. In Madras they call it as grounds, I believe. There in North India they call it as bigas. So the land acquisition rate was fixed at the rate of 200 or so. But UNUS and Development Authority, actually when you take charge of the property, this industrial development co, they have to pay these people the so-called market value of the so-called land, because they are taking the land of UNUS and others. Ultimately, so actually since this rate is not bargainable, definitely they have filed a case. Compensation was fixed at 294 rupees or something like that. Actually 200 rupees. No doubt both of them agreed for 294 rupees per biga. Right? Now the respondents and this development authority, they are approached before the legal service authority or Lok Adalat, and Lok Adalat, after hearing both the parties, they passed the decree fixing the rate at 294 rupees per biga or something like that. Actual rate is 200 only as per the land acquisition officer. Now the settlement was done before the Lok Adalat, so it is equal to decree. So as per the settlement, the Noida Service Authority is liable to pay compensation to the respondents, that is UNUS and others. But when the matter was placed before the land acquisition officer or the additional district magistrate or the DRO, here we call them, he did not agree. What is this? The fixed rate is around 200 rupees or so. Maybe 210 or 220 were acceptable, but 294 is too much. So he did not agree to pay that compensation. Then they filed a case before the High Court. High Court also asked them to pay the money. Noida Authority, they have to pay the money because they have entered into compromise. Definitely they have to pay. But here the problem is the Revenue Authority, who is the competent authority, is not acceptable. This is the main problem. Ultimately, the matter came to the Supreme Court. Supreme Court clearly held that the purpose of Lok Adalat is to give the speedy justice to the compromise cases. That's all. So section 20 of the Lok Adalat is intended to facilitate the settlement of disputes between the parties. When they come to a settlement, when they agree with each other, so it can be taken just as a decree. That's all. It is not it doesn't have any adjudicatory note. That means basing on that, you cannot file a case. This is the problem. No doubt, you may be knowing under the Legal Service Authority Act 1987. So whenever a case is placed before them, if it is compromised, it is equal to acquittal. That's all. If it is a civil case, normally we also are under the impression that it is a decree, but the Supreme Court held that it is not a decree, it is only a settlement, it is only compromise, it has no adjudicatory value. That means basing on this you cannot go in appeal or other things, right? So the writ petition filed by the so-called Yunus and others, it is not accepted. Why? Because land acquisition officer is the competent authority to fix the rate, not these parties. Here what happened is both of them colluded with each other. They have managed the so-called Vokla Industrial Development Authority and they have enhanced the rate. So which is not acceptable by the land acquisition officer also. So therefore this Lok Adalat compromise decree or the award given by the Lok Adalat need not be accepted. So very good decision. Please remember. So the compromise is unholy. Supreme Court said the compromise is not correct. So it is not accepted and therefore appeal is allowed. Now they will decide the rate. So very good case. Here normally we will be under the impression, to conclude I want to tell you, normally we will be under the impression that once Lok Adalat award is passed, it is equal to decree. And the matter can be taken if actually to the court if the so-called compensation is not given. But it is not necessary because the agreement itself is unholy. మీరు లోక్ అదాలత్లో పెట్టుకున్నంత మాత్రాన గవర్నమెంట్ ఉంది కదా అథారిటీ, కాంపిటెంట్ అథారిటీ, వాళ్ళు ఒప్పుకోవాలిగా. యాక్చువల్గా డిఆర్ఓనే పార్టీ చేస్తుంటే ఆయన కూడా అగ్రీ చేస్తుంటే బాధ ఉండేది కాదు. బట్ ఎనీవే దిస్ థింగ్ హ్యాపెన్. సో ప్లీజ్ రిమెంబర్ దిస్ ఎ వెరీ గుడ్ జడ్జ్మెంట్ పర్టికులర్లీ రిగార్డింగ్ లోక్ అదాలత్ డెసిషన్ and read it and enrich your legal knowledge. I have already given the citation in the live law also. If you look through, definitely you will get it. Thank you very much. I have to stop.